Right from the start, notice how quickly this case shifts gears. The judge isn't just reading charges, he's probing competency. Why? Because if a defendant can't understand the proceedings, the entire trial could collapse before it begins. That's a huge deal in criminal law.
769 is now called. James Philip Mendoza, that's you, sir? And Mr. Minaldi is representing you. What is our announcement?
I just want to file the motion for competency evaluation on him. I have a hard time getting through with him, understanding the charges that are against him. Things of that nature.
Let me see if we've got it in our file.
Mr. Mendoza, have you ever been evaluated for mental health issues? Many times. Okay.
But we just got it this morning, Judge.
Oh, we just got it this morning?
Yes, sir. Let me print it out.
Thank you.
Sorry, Judge.
It goes there before it comes to us, so it takes a little while.
The motion, these motions, too often they're kind of conclusory and they need to be articulated in events that support the basis. And it says, does not feel the defendant can understand the charges. That's your perception. Why do you feel that? Is what I need to know. And it appears at this time he is not competent. Why does it appear that he is not competent? That is what I need to know. Go ahead.
But anytime that I speak with him, he seems to have a lot of PTSD related events that interfere with my abilities to communicate with him. I'm never.
Do you have a traumatic event that you had to go through?
2005, I witnessed my little sister's murder in Lubbock, Texas. And my dad died 6 months after that. And I'm basically dead on the inside, sir. I don't even care anymore.
So what happened to your dad?
Pause right here. The defendant just dropped a bombshell. Witnessing his sister's brutal murder back in 2005. Imagine carrying that trauma into every courtroom interaction years later. This isn't just testimony. It's a window into the kind of PTSD that could directly impact competency.
Passed away after my little sister's murder.
Okay.
No.
Well, my father passed away too. That's what's natural of life. I mean, it's when our Creator decides to.
We don't get to have to witness their little sister being stabbed 21 times.
It's terrible. What happened in that case? Was somebody caught?
Yes.
What happened to them?
Life with the possibility of parole.
Okay, they were convicted of murder.
Yes, sir. I had to get on the stand.
How old was the child?
My little sister was 20. I was 22. She was 20.
Well, what was there a relationship she had with that person, or
they were married? Yeah.
Oh, it was. Okay. So, and that happened when?
In 2005.
Okay, 20 years ago.
Yes, sir.
What have you done to get treatment for the trauma?
I've been going to Spindletop. I've been doing really well at Spindletop this last 2 years. I completed my phase 2 part over for parole.
Yes, sir.
I just had 2 more hours of peer support left. I was trying to get my disability check. I was close to getting that. Unemployment from the Beaumont rice mill. I got laid off from there, but they closed that down at the Texas First Rice Mill. So I've been trying to look for work. So I went to the Workforce Commission to see if I could get my CDL, and they were going to pay for that. This happened.
Okay. So you understand what you're charged with here, right?
Yes, sir.
You're not only charged with a 3rd-degree felony of evading arrest or detention, but the indictment also charges you with 2 prior convictions.
Here's where the stakes skyrocket. Evading arrest may sound minor, but when you stack on 2 prior felony convictions, suddenly we're not talking about a slap on the wrist, we're talking about years behind bars. The judge is laying out a roadmap of how past mistakes can snowball in the legal system.
Felony convictions, one, a third-degree felony of DWI, driving while intoxicated, out of Lubbock County, Texas, in 2012.
Right.
After that was final, then it is alleged in paragraph 3 that you committed the offense of illegal possession of a controlled substance with intent to deliver, a first-degree felony, and also out of Lubbock County Court in the 364th District Court there, you were convicted in 2017.
Yes, sir.
So,
Yeah,
okay.
I was coerced on signing that because he told me that they were
Wait,
gonna
wait,
enhance it.
wait.
Sorry. Yeah. finish.
All I know is you've been convicted of that.
Sure.
Has that been reversed in any way?
Not yet.
Until it is lawfully, you can howl at the moon all day long about being coerced or something, but I'm sure they do it the way we do it.
Right.
90+% of all cases are disposed of by pleas.
Research.
We make sure that it's done in a way that that a million people don't come back and say, you know, it wasn't done right.
No. I
So we've
understand.
got it handled in a way. And if there is a problem, it's supposed to, if there is a problem, everybody is held accountable. The defendant, the lawyers, the judge, everybody involved with a plea is held accountable to doing their part to ensure that the plea is sacred. It's done right. It's not done incorrectly. It's not done by force or undue influence. And if we didn't do that, then I can guarantee you this would grind to a halt. And the way the overwhelming number of cases are disposed would all be reversed. And so we're all pretty careful about doing that. But you've got 2 prior convictions.
Listen closely. This is Courtroom Reality Check 101. Over 90% of criminal cases end in plea deals, not trials. Judges hammer this point because if every defendant tried to undo a plea, the justice system would grind to a halt. It's a blunt but honest look at why plea bargains dominate American courts.
Is that until they're proven unauthorized or accomplished incorrectly, they're presumed correct.
Yes.
What you got is this new case of evading arrest or detention. You say this has something to do with your sister's murder?
No, it has to do with getting beat up by 8 policemen in Lubbock, Texas, and I have a live video of them beating out my window.
Okay.
I mean, I stopped,
you're evading
sir.
this charges you with evading arrest, and when you flee a police officer, then
Didn't have any reason to.
you know, are you going to interrupt me all day? We're going to be here a long time.
Yes, sir.
Because this lady right here to my right has to take down everything. When you speak over me, she can't do her job. And then we both get in trouble by the Supreme Court because they say if you interrupt a court reporter and she can't do her job, somebody gets in trouble. So let's don't get in trouble, you or me. So in evading arrests, then you're fleeing from the peace officer, and they're going to turn their lights on and have the siren, and they're going to chase you down until they can get you, unless somehow you can escape, which is rarely done. But and you're saying that when they chased you down, but you're charged with evading arrest. So that is an event that happens before they catch you. When they catch you, the evading arrest ends. They stop. So you're saying for no particular reason, you're being assaulted.
He's saying that was a past instance.
Huh?
That was a past instance.
No. On this, well, in this case, so what is it about
Okay.
this case? So there was no other reason you would be fleeing from a police officer except for a past event?
Sir, I pulled over and I gave him my credentials and they came back clean. He asked me to pull over into the parking lot. When I asked for a speeding ticket, because that's what I got pulled over for, it was for speeding. He didn't give me the ticket or a warning, and he asked me to pull over. And when I saw 2 more policemen coming in, I fled because I'm not used to there's a thing in Lubbock, Texas, where people decal their own vehicles and they pull people over. They're called fake police. And
Oh, so quite naturally, that happens in Beaumont?
I don't know that, sir.
Oh, okay. How long were you in
I
Beaumont?
expected a speeding ticket, and when he didn't
Well,
get
well,
it,
well, hold on.
I didn't know what to
Hold
do.
on.
I freaked out.
So you're not having it your way. So that's the only reason you would have freaked out then and ran, right?
I didn't have the reason to freak out and run. I just did.
You did. Okay, there's no other reason,
No, sir.
right? Is that what you're swearing to?
Yes, sir.
There's no other reason. You had methamphetamine in the car. You don't think I can read?
If I
You had methamphetamine in the car. That doesn't give you a reason to flee?
They give me methamphetamines for my ADHD, sir.
Yeah.
It's a
It's until it's a crime until they can.
But it was just.
Are you going to interrupt all day?
And there it is. The twist. The defendant swears there's no other reason he ran. And the judge hits back with the meth charge. Classic courtroom whiplash. This is why honesty with the bench matters. Because when evidence contradicts your story, credibility takes a nosedive.
You want us to be doing this at midnight?
No, sir. Forgive me.
See, here's the deal. What I get the event is you like to control the situation on your terms. You don't even know me, but I'm the judge and I've taught you what the rules are and you're breaking the rules. I can understand what must have happened at the scene of the crime. You got methamphetamine in your car. You were fleeing from the police. You didn't even think to bring that up, did you? Until I brought it up. See, oh boy, doesn't that make a lot of sense now that the police had just cause, maybe. You were fleeing, you got methamphetamine in the car. That compounds it to a felony offense of evading arrest from a third-degree felony to a more severe case of illegal possession of methamphetamine. Let me see. What does it say? When you talk to a judge, you need to be fully forthright.
I understand.
Don't act.
I wasn't
The
indicted
staff
on it, so I didn't know.
at
to
the
freak
jail.
out.
The staff locate a clear plastic baggie in your possession. The baggie contains clear crystal substance. Crystal methamphetamine. Wait a second. You are being prescribed crystal meth by a doctor. Who did that?
No, I'm taking Wellbutrin right now.
Who prescribed you crystal meth?
No,
No one. No one would.
no, sir.
All right. Okay, I understand things. Yeah. All right. So what are you asking for?
Judge, I'm asking for it to be evaluated so that I
For what?
can feel as if I can have a.
No, evaluated for what?
I'm schizophrenic.
I can't have a conversation with them without hearing I can't have a conversation with them to get down to the root of what his potential options are proceeding in this case. And I'm having trouble with that communication. So if there's another avenue that I would explore or can explore, then I'm.
Well, I mean, you just saw what happened in the dialogue I had with him. He just doesn't want to. I don't find that is a competency issue. Now, if he wants to say, oh, I need, because of my previous experience, when I see a police officer chasing me, I go out of my mind. Well, then that's insanity. That's a different thing altogether. Are you asking for that?
Yes, Judge.
All right. But that's not what it says in this motion.
I can rephrase.
Yeah, you need to rephrase it and then we'll. Because that's what he's articulated to me, not competency issue. He says because of the past event, when police chase him, then he thinks he's going to get harmed somehow.
I'll updated.
But that's apples and oranges here.
Yes, Judge.
Those are two different kinds of things, and they don't mix. You know?
Sir,
He hadn't articulated a competency issue. Okay, send it to me, and then we'll see what we do about it. Then I'll get Dr. Rippon if it's sent to me, articulating those things.
Legal moment here. The judge separates competency from insanity. Competency means you understand the charges and can participate in your defense. Insanity, however, is a defense used to argue that trauma or mental illness made you incapable of distinguishing right from wrong during the crime. Two totally different legal tracks.